Hello and welcome to a fresh episode of Legal Wrangle. In today's episode, we will be presenting some latest judicial developments which have taken place in the field of GST. For this, we have selected some decisions rendered by various high courts touching upon various provisions of GST. The petitioner purchases chickpeas, dries them by heating them to a certain degree, and the resultant product is known as dried chickpeas, which are classifiable under Chapter 0713. During the period of dispute, the petitioner transported the same from Salem to Dindigul. It did not file any e-way bill in view of the exemption statutorily granted. The consignment of the dried chickpeas sent by the petitioner was intercepted by the revenue. The goods were seized and the vehicle ferrying them was detained.
The revenue opined that the goods being transported by the petitioner were classifiable as fried or roasted grams, falling under Chapter 2106 of HSN. Hence, a detention notice was issued and tax was levied with equal penalty. The petitioner challenged such order principally on the ground that when a bona fide dispute as to classification has arisen, it is only the jurisdictional AO who could have ruled on the classification, and that it was not open to the squad officer to have done so.
The High Court noted that a similar issue came up for consideration before the Kerala High Court in a precedent case where it was held that the inspecting authority at best could alert the assessing authority to initiate the proceedings for assessment, that the process of detention of the goods cannot be resorted to when the dispute is bona fide, especially concerning the exigibility of tax and more particularly the rate of tax.
Thus, the proceedings in question were quashed and the writ petition was allowed. The Commissioner of Commercial Taxes, Chennai, was also directed to issue a circular to all the inspecting squad officers in Tamil Nadu not to detain goods or vehicles where there is a bona fide dispute regarding the exigibility to tax or rate of tax.
Petitioners are seeking grant of regular bail in arrest made by Director General of Goods and Service Tax Intelligence, GURUGRAM Zonal Unit under Section 69 of the CGST Act. The department alleges that the petitioners have made bogus billing and adjusted the amount without any transportation of the goods or sale of goods. That only paper transactions were done and amounts have been adjusted, and wrongly claimed relief is of more than 80 crores.
The department further informs that officers from the Director General of Goods and Service Tax Intelligence visited the registered premises of Messrs. Shriram Industries, but said premises were found to be closed. On inquiry, it was learnt that the said premises was closed for the last 5 years, that the premises was controlled and used by Vinay Kumar Gupta, Director of Messrs. Mika Industries. Subsequently, a search was conducted leading to recovery and seizure of a large number of incriminating documents indicating evasion of CGST duty. Statements were recorded of the Director of Messrs. Mika Industry and proprietor of Messrs. Galaxy Metals Products, and investigation was also conducted at the transporter's end.
The High Court therefore viewed that considering the nature and gravity of the offence, and in view of the fact that there were justifiable grounds to arrest the petitioners under Section 69 of the CGST Act, and further in view of the fact that the case involves evasion of more than Rs 80 crores of tax under CGST and the offence is punishable with imprisonment for a period of 5 years, there was no ground to grant benefit of regular bail to the petitioners. The petition was dismissed. Let's move to our next case.
The petitioner filed the present writ, aggrieved by the provisions of Notification Number 11/2017 Central Tax Rate and the clarification dated 9th January 2018 issued by the government pursuant to Entry 5 Clause B of Schedule 2 to the CGST Act, which envisages levying tax on construction activities and deeming the value of the land at 1/3 of the total amount charged. The petitioner claimed that it was entitled to challenge such provisions even if no cause of action had been initiated against its own self.
The High Court referred to the decision of the Apex Court in Kusum Ingots Alloys Limited versus Union of India, wherein it was held that passing of legislation per se conferred no right to file writ petition challenging it if no cause of action was arising. Thus, the High Court noted that the enactment of some legislation, notification or circular did not confer a right to challenge it unless a litigant happened to be affected by the action initiated in furtherance of such provision.
The court thus held that a cause of action is sine qua non for challenging such legislation, notification or circular, and that a writ court cannot adjudicate upon such matters in vacuum. It was also observed that adjudication of issues lacking cause of action would be merely academic exercises consuming public time. Hence, it held that the petitioner herein was ineligible for challenging the constitutional validity of the related notification without having some cause of action. The petition was dismissed. Let's move to the last case.
The Revenue passed orders under Section 83 of the CGST Act attaching bank accounts owned by the directors in the petitioner company. The petitioner claimed that the provisions of Section 83 empowered attachment of property owned by a taxable person. It was further urged that the provisions of Section 2, Clause 107 of the CGST Act define taxable persons to mean a person registered or liable for the same under Section 22 or 24 of the CGST Act. Thus, the petitioner claimed that it was registered under CGST Act and so was a taxable person. Hence, provisions of Section 83 were applicable upon it, but not upon its director under any circumstance.
The High Court noted that the reliance placed by the Revenue upon the provisions of Section 89 of the CGST Act was misconceived, considering that such provisions pertained to recovery of tax, interest or penalty due from a private company in respect of goods or services supplied. Hence, it noted that directors of the company did not ipso facto become liable to pay such amount. It also held that the provisions of Section 83 did not apply upon the directors of the petitioner company in the present case. Hence, the court quashed the attachment orders of the bank accounts of the directors and directed the Revenue to lift the same, being without any authority of law.
This brings us to the end of today's episode of Legal Wrangle. Please stay tuned to TIOLtube.in for our upcoming videos on different areas of taxation law. Please also feel free to share your views with us at editor@tiol.in. Thank you for watching us and have a pleasant day.